in Asian medicine.
When considering purchasing a bird, it is important to know the source of its origin.
I think you certainly want to know if the bird's going to be a pet, whether he was hand-raised or not, because if the chicks that are hand-raised tend to make much better pets than those that are not. And you also want to ask whether the bird was raised in this country or was caught as a baby or as an adult from the wild. One, for what kind of pet it'll make. Two, for possibly what kind of diseases it was exposed to as it came through quarantine. And these days, people that buy birds do a post-purchase exam, take the bird to a veterinarian, and make sure that they did not miss anything, that the bird doesn't have some kind of disease before ever bringing that bird home.
Besides the fact that hand-raised birds make better pets, captive-bred exotics are important in the saving of wild populations.
At the bottom of most people's reason that they have these breeding facilities is to try to develop the expertise to breed all these birds, to relieve the demands on the wild-caught birds so we can ultimately conserve as many species as we can.
People tell me, God, birds make noise, and I say I've never heard a bird make a noise. They're delightful, they're lovely, they may be a little louder, 3 o'clock in the morning when the lupin screams. You may practice levitation, which is the horizontal rising out of the bed. But other than that, they're just delightful creatures, and I love them, and I want to preserve them for the next century.
Each of us has our own ways of looking at the animal world. Now, here's Paul Wilborn with one of his.
You know, my first memory of the zoo isn't about animals at all, but people. It's 2 retired sideshow performers who were visiting the zoo with their beautiful blonde daughter. The father was a giant, and the mother had no legs and kind of walked around on her palms. I watched them in wonder, frightened, and mesmerized. I wondered how nature could produce 2 people like that and then send them such a perfect daughter. But I was only 6 years old, and I had a lot to learn about nature. I wish I could tell you I learned about nature at our zoo, but it was a small city zoo that was run more like a penal colony for second-string animals. The big zoos, I guess, got all the good animals, and we got the cast-offs, like the old mangy lion they kept in a narrow cage. Now, the animals in our zoo specialized in sleeping mostly. I must have gone 10 times to see that lion, but I never saw him awake. The only way I knew he had teeth was one day he opened his mouth and yawned at me. Now, today where that zoo stood, there's a new zoo with natural habitat areas and beautiful animals that are mostly wide awake. That's the way they run zoos now, and children grow up thinking animals are pretty amazing creatures. So when people talk to me about the good old days, I have to remind them that those were the days when zoo lions lived in tiny cages and guys like the giant made a buck wearing tights in a sideshow. Today, the lion roams in natural-looking bells, and the giant just signed a $1 million contract in the NBA. When it comes to zoo animals and giants, I think these are the good old days.
Whether parrots in Amazonia or manatees in Florida, all wild creatures deserve our respect for their species and their habitats. This means the involvement and cooperation of everyone. Awareness and help must come from governments as well as the voting public if we are to protect and save endangered animals. Next week, we'll meet an exotic animal veterinarian and see how she makes her job easier for herself and her patients. Then we'll learn about hip dysplasia in our canine friends and the research that's being done for this crippling problem. Also, we'll explore the Everglades and some of the work veterinarians are doing there to care for the many endangered species that call it home. I'll see you then.
The Gentle Doctor is made possible in part by Henry Schein Incorporated, serving the needs of healthcare professionals for more than half a century. By St. John Laboratories. St. John is the supplier of CET home dental care products for pets. And by Lick Your Chops, creators of optimum nutrition products. Lick Your Chops formulates clinical diets based on bionutritional analysis, available through veterinarians. This is PBS. To purchase Brian Kilcommon's Good Owners, Great Dogs 1-hour VHS training tape, which is fully endorsed by the Humane Society of the United States, please call 1-800-225-9393. The purchase price is $29.95 plus $2.95 for postage and handling.
See it all at the zoo. The Louisville Zoo.
Channel 15 salutes Miller and Bryant carvers, winners of the Gallery 15 Best of Show Award in 1991. Miller and Bryant are carvers of unique wood sculptures. Each work, individually handcrafted, is created by both artists. The carvings reflect a certain uniqueness found deep within the wood grain, which dictates what the image will be. Folk and mythological figures, as well as snakes, birds, and animals, are crafted by these two fine Louisville folk artists.
It's Gregory Hines and a host of hoofers, and I don't have to say anything else. Their feet say it all. Tap into an all-time good time tap dance in America next time on Great Performances.
Friday evening, October 11th.
You have the best seat in the house for educational programs and quality entertainment with Channel 15, TV worth watching.
Funding for this program was provided by the Corporation for Public Broadcasting and by the financial support of viewers like you. From Capitol Hill, hearings on the nomination of Clarence Thomas to the Supreme Court.
Welcome back. I'm Paul Duke of Public Television.
And I'm Nina Totenberg from National Public Radio.
And we're back as the Senate Judiciary Committee continues this extraordinary special session on the nomination of Clarence Thomas to serve on the Supreme Court. A session that was called to investigate an allegation of sexual harassment directed at Judge Clarence Thomas by a young professor who formerly worked for him, both at the Federal Education Department and later when he was head of the government's Equal Opportunity Commission. Judge Thomas was the day's first witness, and he testified and denied very strongly the allegations that had been brought against him by Miss Hill. And then she followed him to the witness chair, and she began to tell her story. And as the hearing recessed for a lunch, she was being interrogated by Republican senators who were trying to see if there were any discrepancies in her version of her relationship, her contacts and dealings with Judge Thomas. Miss Hill has now entered the hearing room. Some of the senators have taken their seats, and we expect the afternoon proceeding to begin momentarily.
One of the questions that's being pursued at the moment or was being pursued just as we closed the morning session by Senator Arlen Specter, who is her principal interrogator for the Republicans, is the question of her contacts with the Judiciary Committee and what she was told. For example, he was pressing her as to whether she was ever told if she made this accusation, her name could be held back and Clarence Thomas would quietly withdraw. She said she could not recall ever having had such a conversation, although she may have, in her words, had a conversation with a staff person about what the various options were once she gave her statement to the FBI and her affidavit to the committee. Anita Hill is in the hearing room now, as we said, preparing to testify. She's got a good deal of her family with her, her mother, who's about to turn 80, and her father, and many of her 12 sisters and brothers. They were not there, Paul, for her opening statement, in which I thought she looked, there's no other word for it other than terrified, and her voice was shaky, and you could hear her breath tremulous. And the hearing room door was closed to anybody who had not entered at the time that she entered. And when her opening statement was over and the hearing room door was open, her family, who had just arrived, I guess, from Oklahoma, was ushered into the hearing room. And I must say, from that moment on, she seemed a good deal more relaxed. Her mother gave her a big hug, and she seemed to sort of relax and ease up. I think that she had not anticipated testifying this morning. Initially, she thought she would be the lead-off witness. Then last night, apparently, she was told that Clarence Thomas would go first. And that decision was made because Chairman Biden decided to give Clarence Thomas the option of what order he wanted to go in. And then today, when Thomas came on, we saw this fight erupt over what the questions would be and who would question and for how long. And after that, the committee went into executive session for about a half an hour and came out and called her rather unexpectedly to the witness stand. We're waiting for the hearing to resume. It should resume any second now. As we can see, the senators, many of the senators are in the room, as is Anita Hill. Chairman Biden is conferring with some of the senators at the moment. And the plan of this committee, they would like to finish with her today and at least also finish with Judge Thomas. They're hoping to finish with Anita Hill by 4 or 5 o'clock this afternoon and then to continue on with Judge Thomas. But committee folks admit that that's a rather optimistic prognostication.
It has been a day of riveting testimony, and I must say, when Anita Hill took the witness chair and testified, she gave some of the most explicit sexual testimony before a congressional committee, certainly that I have ever heard in my days of covering Capitol Hill. And that, of course, had a lot, it dealt with her relationship with Clarence Thomas over the years, and she was quite candid in talking about the times that she had met with Clarence Thomas in his office when he was heading the Equal Employment Opportunity Commission. She talked about his sexual proclivities, his sexual prowess, and also cited some of the comments which he had made to her. And you could sense the tension in the hearing room at that moment, because the senators themselves, I think, were surprised and stunned by some of the things which they had heard. And of course, that was the thrust of her testimony, that Clarence Thomas had continued to make approaches to her when she had made it quite clear that she didn't want to go out with him or have any kind of meaningful man-woman relationship, and that he had made her feel very uncomfortable. And that, of course, was why she regards Thomas's action as a form of sexual harassment.
Well, and it gives you some notion of why these cases are so difficult, why many women do not want to come forward, without making any assessment as to the veracity of her account. This sort of language, this sort of specificity is so uncomfortable for most people to use in public that you and I are not repeating exactly what she said.
And
it's too difficult. It's too uncomfortable.
It sure is. And there's the gavel, and so we go back to the afternoon session of the Judiciary Committee's hearing.
Senator from Vermont, Senator Leahy, will question for half hour, and then we'll go back to Senator Spector.
Good afternoon, Professor Hill.
Good afternoon, Senator.
Professor, we've had a number of discussions almost shorthand discussions here of things you're familiar with and members of the committee are familiar with, but I'd like to take you through a couple of the spots. You mentioned, and there were discussions and questions from you, or answers from you, regarding the FBI investigation. Would you tell us one FBI agent, two FBI agents, I mean, how many spoke to you and where?
There were 2 FBI agents who visited me in my home.
And was that arranged? Just go through some of the mechanics, please.
Well, it was arranged, as I understand it, through Senator Biden's office. I received a phone call from one of the staff members of Senator Biden, and she informed me that she had the date was September 23rd. She informed me that she was had received a fax from me of my statement, and that I should expect a call from the FBI. When the FBI called, they called me at home, left a message on my machine. I returned their phone call that evening after work and arranged for them to come over immediately from Oklahoma City, I believe, to talk with me.
That evening?
That evening, on Monday, September 23rd.
And about what time did they arrive?
They arrived at about 6:30.
And who arrived?
Inspector Luden, and there was one inspector named Inspector Luden, and I don't recall the name of the other individual.
One male, one female?
One female.
Now, was anybody else present for that interview?
No, no one else was present.
It was just the 3 of you?
The 3 of us, yes.
Did they tape record the interview?
No, the one inspector did take notes.
Now, what did they tell you they wanted?
They told me that they had been contacted by the committee, the Judiciary Committee, and that they wanted information regarding the statement that I had made to the committee.
Did they have that statement with them?
I do not believe that they had the statement with them. It was clear from the questioning that they had read the statement, and I believe at one point in the evening, Inspector Luden did say that he had read the statement.
When you made that statement, you had it typed up and you signed it, is that correct?
I typed it and I signed
it. And kept a copy for yourself?
I only telefaxed the copy. I did keep the copy, the original.
And you still have that?
I still have it.
Have you given copies of that to anybody other than the copy you telefaxed? To anybody else?
Well, I have shared the statement with my counsel.
Let me make sure I have this well in mind. You have the original copy, correct?
Yes.
And you telefaxed a copy, which in itself made copies to the committee, is that correct?
Pardon me?
You faxed a copy to the committee, is that correct?
Yes.
Gave a copy to your counsel?
Yes.
Did you give a copy to anybody else?
Other than counsel, I don't believe that I gave a copy to anyone else.
You did not give a copy to the FBI agent?
No, they told me that they had received a copy from the committee.
Did you give a copy to any member of the press?
No, I did not.
And so your counsel, the fax copy, and your own copy are the only ones that you've had control of, is that correct?
Yes.
Now, did the FBI give any indication to you how you should answer? I mean, great detail, little detail? How? How did it go about? How was the interview done?
Well, the interview was conducted limited as much as I felt comfortable giving. The questions that were asked were fairly general in terms of what kinds of comments were made.
Did they? Oh, go ahead. I don't mean to cut you off.
No, that's fine.
Now, in your statement that they told you they had, in that statement you were fairly specific about the kind of sexual discussions that you say Judge Thomas has with you. Is that correct, Professor?
Yes, I felt that I was fairly specific.
Did they refer to that specificity when they talked with you?
I'm sorry?
Did the FBI agents refer to that specificity when they talked with you?
They simply said that if I got to any point with regard to being specific that made me uncomfortable, that I should withdraw from the conversation, or I could perhaps give the information to the female agent who was there. They did not indicate that my comments were not specific enough, or that they needed more information.
Did they say that they might come back and talk with you again?
Yes, he almost assured me that he would come back.
But did they?
And in fact, they did not come back. I did receive a phone call the next day to verify 2 names of persons that I had given them, but they did not return for more information.
And has anybody come back to talk with you since then? From the FBI? From the
No,
FBI.
I have not spoken with FBI since then.
Now, you got a chance to read their report about you this morning,
Yes,
did you
I
not?
did.
Let me, you could just bear with me a moment. I want to read. Do you have that before you?
Yes, I do.
Would you turn to the part of the FBI report, and someone's getting me a copy now because I do not have one, but turn to the part where you have reference to the last time, or the time you went out to dinner with Judge Thomas. You know the one I'm referring to?
Mm-hmm.
I believe it's on second. Let's see. Yes, on page 4 of it, where is there a line that said Hill, according to the FBI report, Hill stated that when she left EEOC, Thomas took her out to eat. You find that in a paragraph of Professor Hill.
I'm sorry. What page are you referring
On
to?
page 3 of
Page
your
3,
report,
okay.
you see the paragraph which begins, I think it's a 1, 2, 3, 4, 5 paragraphs down. Hill stated that when she left EEOC, Thomas took her out to eat.
Yes.
Would you read the rest of that sentence, please?
Took her out to eat and told her that if she ever told anyone about their conversation, he would ruin her career.
Now, is that precisely the way it is in your statement?
That is not precisely the way it is in my statement. That is not what I told the FBI agent.
And what did you tell the FBI agent?
I told the FBI agent that he said that it would ruin his career.
Now, the FBI agents, did they ask you to give them any written statement of any sort? I know
No, they didn't ask for any written statement.
Did they ask if you'd be willing to come to Washington to talk with them?
They didn't ask that.
Did they ask if there's anything else you might be willing to do?
No, they didn't mention anything further except for coming back for additional questioning.
Did they ask you if you'd be willing to take a polygraph?
They asked if I would be willing to take a polygraph.
And what did you say?
I answered yes.
Let us go to that last meal has been discussion. It is your statement that the FBI misunderstood you, and it is, as you have said in each of your statements, that Judge Thomas said if this came out, it would ruin his career, not that he would ruin your career.
Exactly.
Where did you go for dinner that time?
I do not recall the restaurant, the name of the restaurant.
Was it nearby?
It was nearby work.
Do you remember the type of restaurant?
Oh, no, I don't. It wasn't anything that was memorable to me, the type of food that we had.
Do you remember how you got there?
I believe that the driver for Chairman Thomas, or then Chairman Thomas, took us, Mr. Randall, and dropped us off at the restaurant.
And went right from the office?
Went from the office.
After dinner, how did you get home?
I took the subway home, if I recall correctly. As I'm recalling, I'm not sure how I got home.
Do you recall whether then Chairman Thomas offered you a ride home?
No, he did not offer me a ride home.
Do you know whether his car came to pick him up?
I don't know how he got home either.
Do you recall approximately how long a time was this? Was this a case you had to stand in line a long time to get a table or anything like that?
No, we walked right into the restaurant, sat down. I imagine that it was about an hour also.
Do you have cocktails?
I did not have cocktails.
Anything alcoholic?
I don't recall having anything alcoholic.
How long into the meal did the conversation you discussed come up? How long were you into the meal before the conversation you just described came up?
I believe it was well into the meal, maybe midway, halfway or beyond.
And what did you say in response?
My response was that I really just wanted to get away from the office and leave that kind of activity behind me.
Did he ask you if you intended to ever make this public?
He did not ask me that.
Now, you've discussed somewhat here earlier today about why you did not come forward with these allegations before. Had you come forward with them, at the time of your employment, either at the Department of Education or at the EOC, what would have been the mechanism to come forward with the allegation?
I do not know this of my own knowledge. I've been told, or I've heard suggested that the Oversight Committee would have been the proper authority to deal with such an issue.
Oversight within the department or
No,
here on the Hill?
Here on the Hill, the Congressional Oversight Committee. We had oversight over the EEOC. But I don't know that. I just heard that.
Did you at any time consider going somewhere, wherever the appropriate place might be to make this public?
I considered it, but I really, at the time, I did not clearly think out exactly where I would go.
Had you come forward, what do you think would have happened?
Well, I can speculate that it might have been difficult. I can speculate that had I come forward immediately after I left the EEOC, I can speculate that I would have lost my job at Oral Roberts.
Professor Hill, this morning, Judge Thomas testified before this committee. I don't know if you saw his testimony or not. So let me read from his statement. He said, "I cannot imagine anything that I said or did to Anita Hill that could have been mistaken for sexual harassment. With that said, if there's anything that I have said that has been misconstrued by Anita Hill or anyone else to be sexual harassment, then I can say that I'm so very sorry and I wish I had known. If I did know, I would have stopped immediately, and I would not, as I have done over the past 2 weeks, had to tear away myself trying to possibly have done, but I have not said or done the things that Anita Hill has alleged. And you're aware of that statement by Judge Thomas. You agree with that?
Do I agree with his statement?
Yeah.
No, I do not.
Well, then let us go through in summary. What are the things that you felt he should have known were sexual harassment?
Well, starting with the insisting on dates. I believe that once I gave a response to the question about dating, that my answer showed him that any further insisting was unwarranted and not desired by me. I believe that the conversation about sex and the constant pressuring about dating, which I objected to, both of which I objected to, were basis. There was enough for him to understand that I was unappreciative and did not desire this kind of attention in the workplace. I think that my constantly saying to him that I was afraid that because he was in a supervisory position, that this would jeopardize my ability to do my job, that should have given him notice.
Did he ask you, you said that he asked you for dates many times. By many, what do you mean? Can you give us even a ballpark figure?
Oh, I would say over the course of
the Department of Education and the EOC.
Oh, I would say 10 times, maybe, I don't know, 5 to 10 times.
And you said no each
Yes.
time, with the exception of the departure dinner, which you just testified to here.
That was not a date, and I made clear that it was not considered to be a date.
And on that one, while you rode to the restaurant with him, you did not leave the restaurant with him. I mean, you did not go.
No, I did not.
You took the subway home. Now, you said you made it clear to him on the discussions of pornography and all that you didn't like what he was saying. Is that a fair statement of yours?
Yes, it is.
Were these often or ever the discussions of pornography or sexual acts coterminous with a request to go out on a date? I mean, did they come up in the same conversation, or was one on one day and one on the next?
I cannot say that they came up in the same conversation.
What did you say? Well, let's go back to this. You said that he had described pornographic movies to you. Is that correct? Yes. And explicitly described them?
Yes.
When that happened, what would you say, or what would you do?
I would say, specifically with the pornographic movies or material, I would say that I'm really not interested in discussing this. I'm uncomfortable with your talking about this kind of material. That I would prefer that not to discuss this with you.
You'd be that clear about it. Would the discussions end when you said that? I mean, for that occasion.
Yeah, for that occasion, very often they would. Sometimes I would have to say it more than once, but yes, they would.
You said this, did you ever hear him say this to anybody else?
These kinds of,
Yes.
I did not hear it.
Did anybody ever tell you that he did?
No, no one ever told me that he did the same thing.
Did he say these things to you in your office at any time?
There might have been some occasion when he said it in my office.
But you do recollect him saying it to you in his office?
Yes.
Is that a big office or a small office? They could either of the two jobs you held.
Well, I think both were relatively large offices. I remember the EEOC set up a little bit more clearly. I was there longer, but they were both large offices.
Did you, at some time when you're saying it, did you say, look, I don't want to hear about this, walk out the door, and just
There
walk
were
out the door?
times when I would walk away. If I were in a situation, I could get up from his office and just leave, yes.
Did he ever try to stop you from going out the
No,
office?
he did not. Not physically.
In any fashion?
Well, he
Did
may.
say, like,
he might.
don't go any further?
Oh, not. And he might have said, "Don't go," or okay.
What you mentioned happening in the cafeteria? People within earshot? Anybody within earshot when it happened in the cafeteria?
Not that I could see. Anyway, there may have been someone in earshot.
Now you testified to this today. You've given a statement that we've referred to. You discussed it with the FBI. Let's go back more to a time contemporaneous when this happened. Did you discuss it with anybody at that time?
Yes, I did.
And who did you discuss it with at that time?
Well, Sue Hirschner. I did discuss it with Sue Hirschner. She was a friend of mine and someone I confided in. And I spoke of this to other people also.
Let's talk about Ms. Hirschner. Was that when you were at EOC or at the Department of Education?
That was at Education, I believe.
And what was your relationship to her? Was it a co-worker?
No, she was not a co-worker at Education. We had never worked together. She was a friend from law school.
How often did you discuss it with her?
Maybe once or twice. We did not discuss it very often. I can't say exactly how many times.
What was the nature of your discussion with her?
Well, I was upset about the behavior, and that's what I was expressing to her as a friend, that it was upsetting and that I wanted it to stop, and maybe even ask for advice or something to help me out of the situation.
And did she offer advice?
I don't recall her offering any advice. I'm not sure exactly what she said. I think she offered more comfort because she knew I was upset.
And did you discuss it with somebody else?
Yes, I have discussed it with other people.
At that time?
Yes, at that time.
And who was that professor?
I discussed it in passing. Well, no, not in passing. I discussed it with Ellen Wells, who is another female friend. She and I were close during the time, and we had a conversation. In particular, we were talking about what I should do, how I should respond to it, what might make it stop happening. At the time, in addition, I was dating someone, John Carr, and we discussed it because I was upset by it, and I wanted to let him know why I was upset, and again, just trying to see if there might be some way that he could handle this differently.
And did he give you a recommendation?
I don't recall whether he did.
You said when you talked to Ms. Was there anybody else you recall?
At this point, I don't recall.
You said when you talked to Ms. Hirschner, you were very concerned, upset, and that's why you did. Describe to us
was really upset. I felt like my job could be taken away or could be at least threatened, that I wasn't going to be able to work, that this person who had some power in the new administration would make it difficult for me in terms of other positions. It was threatening from the job in terms of my job, but it was also just unpleasant and something that I didn't want to have to deal with. And it wasn't as though it happened every day, but I went to work during certain periods knowing that it might happen.
You said in your statement that at one point you were hospitalized for 5 days. And did you, and am I correct in understanding your statement, you felt it was related to this?
Yes, I do believe that it was related to the stress that I felt because of this.
Had you ever had a similar hospitalization?
I had never had a similar hospitalization.
Now when you think back on it, to describe how you felt at the time, how do you feel about it today?
Well, I'm a little farther removed from it in time, but even today I still feel hurt and maybe today I feel more angry and disgusted. I don't feel quite as threatened. The situation, I'm removed from it. My career is on solid ground, and so the threat is not there. But the anger and hurt is there.
In your statement, you had said that between 1981 and 83, you spoke to only one person about these influences, Susan Hirschner, and you talked about two others. Now, is there a contradiction there?
Well, in my statement, I do say that I only spoke with one person. That is all that I recalled at the time that I made the statement. I'm recalling more about this situation. I really am finding that I repressed a lot of the things that happened during that time. And I am recalling in more detail. When I made the statement, too, I might add that I made it rather hurriedly, and even though I had been thinking about the situation, I had not perhaps given all of the consideration in terms of who I had told that I should have for such a statement.
Since this began, for whatever series of reasons, and there's been discussion, debate about how all this came about, this has become a most public matter. You can't get much more public than the situation we're in right now. And Judge Thomas has been up for confirmation on other occasions. Did you think, there's other occasions you're coming forward and giving, in effect, the same testimony you're giving here today?
I may have considered it, but I was not contacted in those confirmation hearings, and I did not come forward on my own in that confirmation hearing, the most recent one.
This one?
Not this one, but the prior one.
Had you been contacted in the prior one?
I had not been contacted in the prior one.
You were contacted in this one?
And I was contacted in this one, yes.
I realize, and my time is virtually up, this requires speculation. You're going to answer as you see fit. Had you not been contacted, did you come forward this time?
I cannot say that I would have.
Chairman, I have a lot more questions, but my time is up, and I'll stop at that time. Please you say this to speak those.
We now recognize Senator Pennsylvania.
Chairman. Professor Hill, there is a report in the Kansas City Star of October 8, 1991,
August interview with the Kansas City Star, Anita Hill offered some favorable comments regarding Clarence Thomas and some criticism. And then further on it says, quote, quoting you, judicial experience aside, the Clarence Thomas of that period, referring to his days in EEOC early, would have made a better judge on the Supreme Court because he was more open-minded. Now, how is it that you would have said that Judge Thomas in his early days at EEOC would have made a better judge, at least an adequate judge, considering all of the things you have said that he told you about at the Department of Education and also at EEOC?
That opinion, Senator, was based strictly on his experience, his ability to reason. It was not based on personal information, which I did not see fit to share with that reporter. I was trying to give an objective opinion as possible, and that's what that statement is based on. In addition, very early on, I believe that I was commenting on his time at education. Very early on at education, I was not experiencing the kinds of things that I later experienced with Judge Thomas.
But when you make a statement in August 1991 and say that judicial experience aside, the Clarence Thomas of that period would have made a better judge on the Supreme Court because he was more open-minded, you are making a comparison as to what Judge Thomas felt judicially early on before he changed his views on affirmative action. So that's the reference to at that period. But when you say that Judge Thomas would have made a better Supreme Court justice, you are saying that at one stage of his career, he would have made an adequate Supreme Court justice.
I'm not sure that that's what I'm saying at all. I am sure that what I was trying to give to that reporter was my assessment of him objectively without considering the personal information that I had. Now, if I had said to him, I don't think he would have made a good judge because of personal information that I have, then I think I would have had to explain that. I would have, or at least created some innuendo that I wasn't ready to create. In addition, I think as a university professor, he's quoted as a university professor, you have some obligation to try to make objective statements. And that's what I was doing. I was attempting to make an objective statement about the individual based on his record as a public figure. And I was not relying on my own private understanding and knowledge.
Well, let's take it the way you have just re-explained it. An objective evaluation without considering personal information as a law school professor to make a comment on his record as a public figure. How could you conclude in any respect that he would be appropriate for the court, even if you say that was without considering the personal information, if you had all this personal information?
I did not say that he would be appropriate for the court, Senator. I said that he would make a better judge. I didn't say that I would consider him the best person for the Supreme Court.
Well, when you say he would have made a better judge at one point, are you saying that there is not an explicit recommendation or statement that, as you said earlier, on the basis of his intellect, aside from personal information, he would have been a better Supreme Court justice?
I'm sorry, would you rephrase that?
Sure. Isn't the long and short of it, Professor Hill, when you spoke to the Kansas City Star-Reporter, that you were saying at one point in his career he would have been okay for the Supreme Court?
No.
What were you saying as to Judge Thomas's qualifications for the Supreme Court when you spoke to the reporter in August?
I'm sorry, excuse me for interrupting. We were speaking in terms of his being open-minded. One of the comments that the reporter made was that some have complained that he has a set ideology and that he won't be able to review cases on their own. My comment went to whether or not he did have that set ideology. And it was that now he did, whereas a few years ago, I did not find that to be so. I found him to be more open-minded. So that in that sense, I believe that he was better suited for a judicial position at that time than now. And that's all that I was referring to, that particular comment or line of concern about the nominee's qualifications for being on the court.
Well, it is certainly true, Professor Hill, that your statement has a comparative, that Judge Thomas would have been a better judge of the court, Supreme Court, at an earlier point of his career. But if you stand on your statement that this interview does not contain a recommendation for Judge Thomas, so be it. That's your position?
Yes, it does. That is my position. Thank you.
Did you ever maintain any notes or written memoranda of the comments which Judge Thomas had made to you?
No, I did not.
In your statement and in your testimony here today, you have said that you were concerned that Judge Thomas might take it out on me by downgrading me or by not giving me important assignments. I also thought that he might find an excuse for dismissing me. As an experienced attorney and as someone who was in the field of handling sexual harassment cases, and didn't it cross your mind that if you needed to defend yourself from what you anticipated he might do, that your evidentiary position would be much stronger if you had made some notes?
No, it did not.
Well, why not?
I don't know why it didn't cross my mind.
Well, the law of evidence is that notes are very important. You're nodding yes, and present recollection refreshed, right?
Yes, indeed.
Prior recollection recorded, right?
Yes.
In a controversy, Judge Thomas took some action against you, and you had to defend yourself on the ground that he was being malicious in retaliation for your turning him down. Wouldn't those notes be very influential, if not determinative, in enabling you to establish your legal position?
I think that would be very influential, yes.
So given your experience, if all this happened, since all this happened, why not make the notes?
Well, it might have been a good choice to make the notes. I did not do it, though. Maybe I made the wrong choice in not making the notes. I'm not a person, I was not interested in any litigation. I was not interested. If I had been dismissed, very likely I would have job. I was not interested in filing a claim against him, and perhaps that's why it did not occur to me to make notes about it.
Well, I'm not on the point of your being interested in making a claim. What I am on the point of is your statement that you were concerned that he might take retaliatory action against you, and therefore the inference arises that the notes would have been something which would have been done by an experienced lawyer.
One of the things that I did do at that time was to document my work. I went through very meticulously with every assignment that I was given. This was this really was in response to the concerns that I had about being fired. I went through, I logged in every work assignment that I received, the date that it was received, the action that was requested, the action that I took on it, and the date that it went out. So that I did do that in order to protect myself. But I did not write down any of the comments or conversations.
Well, when you comment about documenting your work to protect yourself because of concern of being fired, wouldn't the same precise thought about documentation have led you to document Judge Thomas's statements to you?
Well, I was documenting my work so that I could show to a new employer that I had, in fact, done these things. I was not documenting my work so that I could defend myself or to present a claim against him.
Well, why would you need to document with precision the time the assignment came in and the time you completed the work for a new employer? Wouldn't that kind of documentation really relate to the adequacy and speed of your work at EEOC contrasted with a finished product which you could show to a new prospective employer?
I'm sorry, I don't quite understand your question. Are you saying that the new employer would not be interested in knowing whether or not I turned my work around quickly?
What's the relevancy as to when you got the assignment and how fast you made it?
Because it goes to whether or not I was slow in turning around a work product in a very fast-paced job situation.
Mr. Hill, as you know, the statute of limitations for filing a case on sexual harassment is 180 days, right? A very short statute of limitations because of the difficulty of someone defending against a charge of sexual harassment, right?
Well, it is a short turnover time. I'm not quite sure exactly why it is that short. That is one of the reasons that it is so short.
Well, you're an expert in the field. Delaware State College versus Red's 101 Supreme Court reporter in 1980. Johnson versus Railway Express Agency, 421 U.S. reports comment about the short period of limitations because of the difficulty of defending against a charge of sexual harassment.
But I don't believe either of those cases say that that's the only reason. And let me clarify something. I consider myself to be an expert in contract and commercial law, not an expert in the field of sexual harassment or EEO law. I don't even teach in that area anymore.
Well, you did teach civil rights law.
At one point.
You taught civil rights law after 1980, right?
Yes, I have.
Well, all right, it's one of the reasons for having a short period of limitations to give someone an opportunity to defend himself against the charge of sexual harassment because they're hard to defend.
Certainly.
Statute of limitations in a contract case, 6 years.
Well, in some states, the statute of limitations is not set. It's not a set thing. It varies from state to state.
Federal statute of limitations for crime, 5 years.
I'm not a criminal lawyer, but I don't know.
Do you know of any statute of limitations which is as short as 6 months besides sexual harassment cases?
Do I know of any? No, not offhand.
Well, in the context of federal law limiting a sexual harassment claim to 6 months because of the grave difficulty of someone defending himself in this context. What is your view of the fairness of asking Judge Thomas to reply 8, 9, 10 years after the fact?
I don't believe it's unfair. I think that that's something that you have to take into account in evaluating his comments.
I had asked you this morning, Professor Hill, about a statement which was made by Ms. Berry, and I had asked you then in the context of your saying that she didn't know you and you didn't know her, and you then expanded that to say that she didn't know your social life. You did say that she had an opportunity to observe you and Judge Thomas at EEOC. I want to come back to that for just a moment, because the New York Times says this, quote, in an interview, Ms. Berry suggested that the allegations were a result of Ms. Hill's disappointment and frustration, that Mr. Thomas did not show any sexual interest in her. Now, aside from saying that Ms. Berry doesn't know about you on the social side, what about the substance of what Ms. Berry had to say?
What exactly are you asking?
Well, I'll repeat the question again. Was there any substance in Ms. Berry's flat statement that, quote, Ms. Hill was disappointed and frustrated that Mr. Thomas did not show any sexual interest in her?
No, there is not. There is no substance to that. He did show interest, and I've explained to you how he did show that interest. Now, she was not aware of that. If you're asking me, could she have made that statement? She could have made the statement if she wasn't aware of it, but she wasn't aware of everything that happened.
Professor Hill, do you know a man by the name of John Doggett?
Pardon me?
A man by the name of John Doggett?
John Doggett?
John Doggett, sir?
Yes, I have met him.
I ask you this, Professor Hill. In the context of whether you have any motivation as Judge Thomas. What was your relationship with Mr. Doggett?
I don't recall. I do not recall. We were friends, but it wasn't anything, I just don't know.
Well, before I pursue this question, I will give you a copy of his statement, give you an opportunity to read it before I ask you about that, and I will do that. I will do that at a break. How close were you to Dean Charles Covey of the Oral Roberts Law School?
He was the dean of the law school. I was there for a year. I believe he was the dean for a year while I was there. We worked together.
One of the comments which was made by Dean Covey related to your voluntarily driving Judge Thomas to the airport on an occasion when he came to speak at Oral Roberts Law School. And my question is that in a context where you had responded to some people who asked you to make inquiries of Judge Thomas, in a context of his having said these things to you as you represent being violations of the civil rights law constituting sexual harassment, given that background, why would you voluntarily agree to drive Judge Thomas to the airport?
I really don't recall that I voluntarily agreed to drive him to the airport. I think that the dean suggested that I drive him to the airport, and that I said that I would. But at any rate, one of the things that I said was that I intended to hope to keep a cordial professional relationship with that individual. And so I did him the courtesy of driving him to the airport.
Well, when you say you wanted to maintain a cordial professional relationship, why would you do that, given the comments which you represent Judge Thomas made to you, given the seriousness of the comments, given the fact that they violated the Civil Rights Act? Was it simply a matter that you wanted to derive whatever advantage you could from a cordial professional relationship?
It was a matter that I did not want to invoke any kind of retaliation against the professional. It wasn't that I was trying to get any benefit out of it.
Well, you say that you consulted with him about a letter of recommendation. That would have been a benefit, wouldn't it?
Well, that letter of recommendation was necessary. The application asked for a recommendation from former employees.
Judge Thomas testified at some length this morning about his shock and dismay and anger, and specified a group of facts which he said, in effect, undercut your credibility when you moved with him from the Department of Education to EEOC, when you went with him voluntarily, and I take it was voluntary, to go to a speech which he made at Oral Roberts Law School, when you contacted him about the speech at the University of Oklahoma, when you asked him for his guidance and his advice. Would you say, Professor Hill, that all of those contacts and the continuation of a cordial professional association relationship have no bearing at all on your representation that he made these disgusting comments to you and was guilty of sexual harassment in violation of the Civil Rights Act?
I wouldn't say that they have no bearing, but I believe that I've explained a number of those factors. I've talked to you about why I went to the EEOC. I talked to you about, would you list those again? I've forgotten what representations you were suggesting.
Well, I know that you have explained or given an explanation as to why you moved from the Department of Education to EEOC. And I know you have an explanation for the Oklahoma University invitation, but nonetheless you called him. And I know you have an explanation for the Oral Roberts incident. But in seeking to evaluate the credibility between you and Judge Thomas, I'm asking, and I think you've already answered it, that it does have some relevancy as to whether you would maintain over a long period of time this cordial association if he had been so disgusting to you, had victimized you with sexual harassment, and had violated the Civil Rights Act.
Well, the things that occurred after I left the EEOC occurred during a time, any matter, calling him up from the university, occurred during a time when he was no longer a threat to me of any kind. He could not threaten my job. I already had tenure there. He could not threaten me as he had implicitly, at least, at the EEOC. I was no longer working with him at the EEOC. So I was removed from the harassment at that point. I did not feel that it was necessary to cut off all ties or to burn all bridges or to treat him in a hostile manner. Moreover, I think that if I would have had to explain this, the whole situation that I've come forward with today. I think what one has to do is try to put oneself in the situation that I was in. And I think it's not an atypical situation. It was perhaps all of those things, if you look at them without any explanation, might suggest that there was no harassment. But there is an explanation for each of those things. And given the judgment that I made at the time that I did want to maintain some cordial but distant relationship, I think that there is no contradiction in what I'm saying and those actions.
All right, I'm prepared to leave it at that. There is some relevancy to that continuing association, questioning your credibility, but you have an explanation. I'll leave it at that. I want to ask you about one statement, Charles Coffey, Dean Coffey, because he knew you, Judge Thomas, very well. I want to ask you for your comment on it. There's a similar reference in the Doggett statement, which I'm not going to ask you about because you haven't read the Doggett statement, and you say you do not remember him, and out of fairness, I want to give you a chance to read that first. But you do know Dean Coffey, and he does know Judge Thomas, and this is his concluding statement, quote, I find the references to the alleged sexual harassment not only unbelievable, but preposterous. I'm convinced that such is a product of fantasy. Close quote. Would you care to comment on that?
Well, I would only say that I'm not given to fantasy. This is not something that I would have come forward with if I were not absolutely sure about what it is I am saying. I weighed this very carefully, I considered it carefully, and I made a determination to come forward. I think it's unfortunate that that comment was made by a man who purports to be someone who says he knows me. And I think it's just inaccurate.
Well, you have added during the course of your testimony today 2 new witnesses whom you made this complaint to. When you talked to the FBI, there was 1 witness. And you're testifying today that you're now, quote, recalling more, that you had repressed a lot. And the question which I have for you is, how reliable is your testimony in October of 1991 on events that occurred 8-10 years ago when you are adding new factors, explaining them by saying you have repressed a lot, and in the context of a sexual harassment charge where the federal law is very firm on a 6-month period of limitation, how sure can you expect this committee to be on the accuracy of your statements?
Well, I think if you start to look at each individual problem with the statement, then you're not going to be satisfied that it's true. But I think the statement has to be taken as a whole. There's nothing in the statement that, nothing in my background, nothing in my statement, there's no motivation that would show that I would make up something like this. And I guess one really does have to understand something about the nature of sexual harassment. It is very difficult for people to come forward with these things, these kinds of things. And it wasn't as though I rushed forward with this information. I can only tell you what happened, and to the best of my recollection, what occurred, and ask you to take that into account. Now, you have to make your own judgment about it from there on, but I do want you to take into account the whole thing.
Well, I will pursue the question of motivation on my next round because the red light is now on.
Thank you very much, Senator. There's a half hour that we are going to use. I'm going to yield the bulk of it to Senator Heflin, but I'm going to ask just a few. Would you prefer a break? Oh, I thought, because you've been sitting here a long time.
I'll take a break. I need the statement from Mr. Doggett.
Well, we're not going to go to Mr. Doggett now. What we'll do is, before we get back to Senator Specter, we will break and give you an opportunity to read that statement, which I might add we're reading for the first times ourselves. Okay. But we're not going to break now, so there'll be order. Order in here. We will break after Senator Heflin and I ask our questions, and then what we'll do is give you time to read the statement. And as I said, give all of us time to read the statement, because this is news to me as well as the rest of the committee, other than Senator Specter, the statement itself. Now, let me ask you, following up on what Senator Specter has just said, and Senator Specter and all of us acknowledge that there is a need to understand the nature of sexual harassment and the way in which people respond to that harassment. And one of the things that you have repeatedly said here, and you have said publicly prior to coming here, is that this was not your idea. You did not want to come here. You have stated, and it appears to be so, that you are a reluctant witness, not one who was out charging down the road. And as Senator Specter acknowledged, and every expert in the field acknowledges, that is not conduct that was inconsistent with whether or not someone is harassed. Now let me ask you this, though, because I'm sure a lot of people, including me, are wondering about it. You indicated, and it's totally understandable, that you repressed a lot. And again, as every expert over the years whom I've spoken about this subject, not about you, not about this incident, but about the nature and the conduct of harassment and the respondent, the person harassed, how they respond. That's not at all an unusual notion, that there is repression, person repression, thinking about it. But what I'd like to ask you about is, notwithstanding that fact, can you lay out for the committee what, in fact, the sequence of events that did bring you forward? You and I had a long discussion, when I say long, relatively long discussion, the night that we convinced that the Senate agreed, we meaning the members of the committee, the Senate agreed to withhold the vote on Judge Thomas and put that vote off until this coming Tuesday, if I believe I'm correct, at 6 o'clock. And I called to tell you you'd be receiving a subpoena, and for you not to be alarmed by that when someone knocked at your door. And then you and I had a discussion about the sequence of events that brought you here. And you have made reference to that sequence directly and indirectly on this record and off the record, off this record, but publicly. Now, this is not something that you initiated. Is that correct? And you were contacted by a staff, and you were contacted by a staff person from the United States Senate. Is that correct? And you indicated to me you thought that staff person, and it's perfectly understandable you would, in my view, thought that staff person was a staff person from the Judiciary Committee. Yes. Is that correct? And then you were contacted subsequently by two other staff persons.
Yes. Well, let me clarify
Please,
that. I thought that staff person was acting on behalf of a member of the committee.
I see.
With regard to their duties on the committee.
I see. Which is what I understand to be the case, legitimately so. we talked, I had indicated to you that the committee, to be more precise, me, and in terms of my responsibility as chairman to make known the allegations to the committee as a whole, did not occur until after the committee had begun its meeting. No reason, that's not your responsibility, that's mine, but I just, and what I want to get at is this, not who spoke here first and second and third and all of that. I want to get at this issue because it seems to me it does go to the question of, it does go to explain your assertions here this morning as to how you got here. What ultimately, what was the final thing that made you decide that you must go public knowing that all this was true?
Well, I was presented with the information by a newspaper.
Information you had submitted to me and I had distributed to the committee. You were presented with that information.
Over the telephone. It was read to me verbatim by a member of the press.
Now, the thing that was read to you verbatim was the statement that you had submitted and asked me to distribute to the committee.
Yes.
So in your view, you're here as a result of some unexpected event.
Definitely.
An event that turned out not to be within your control.
Definitely.
And you do not, therefore, or do you consider yourself part of some organized effort to determine whether or not Clarence Thomas should or should not sit an event?
No, I had no intention of being here today. None at all. I did not think that this would ever, I had not even imagined that this would occur.
Now, as I listen to you today, in answering very direct questions by Senator Spector, fair but direct questions, you did not, as you stated here, and correct me if I'm wrong, you appear not to have from the outset viewed what was happening to you in terms of your need to have a record to be able to retaliate or to sue or to do anything other than try to stop what was happening, what you allege to be happening from happening. Is that correct?
That is correct. That was my motive at the time, just to stop the activity.
Is this what you anticipated?
This? No, not at all. Not in my, I would have never even dreamed. I just can't imagine.
Is it reasonable to say that it was your hope and expectation that it would not come to this?
It was exactly what I was trying to, really very difficult, I made great effort to make sure that it did not come to this. I was meticulous. I was making every effort to make sure that this public thing did not happen. I didn't talk to the press. I was called by the press on July 1st. I did not talk to the press. This is exactly what I do not want.
And is it fair to say that attitude prevailed up until the moment the press person called you and read you your statement?
Well, the attitude of not wanting this to happen, it prevails even today.
Well, we're beyond that point.
Yeah, we're beyond that point, but it certainly prevailed up until that point.
The reason I bothered to ask that is that it's important, it seems to me, for the committee to know why someone would move from one point point to the next and still hope that you didn't have to get to the end point, with the end point being in total public at this moment, like you are at this moment. Am I misstating in any way your desires as you moved along in this process, or were moved along in this process?
The desire was never to get to this point. The desire, and I thought that I could do things, and if I were cautious enough, that I could control it so that it would not get to this point. But I was mistaken.
I thank you. I yield to my lieutenant from Alabama.
Professor, we heard Judge Thomas deny that he'd ever asked you to go out with him socially, dating, and deny all allegations relative to statements that allegedly he had made to you that involved sex organs, pornographic films, material, those types of things. And you have testified that occurred, that he asked you to date, go out socially. You testified here today relative to the statements that he made to you about pornographic films and materials and other things. And I suppose every member of this committee have to come down to the ultimate question of who's telling the truth. My experience as a lawyer, judge, is that you listen to all the testimony, and then you try to determine the motivation for the one that is not telling the truth. Now, in trying to determine whether you are telling falsehood or not, I've got to determine what your motivation might be. Are you a scorned woman? Are you a zealot civil rights believer that progress will be turned back if Clarence Thomas goes on the court?
No, I don't. I think that I have my opinions, but I don't think that progress will be turned back. I think that civil rights will prevail, no matter what happens with the court.
Do you have a militant attitude relative to the area of civil rights?
No, I don't have a militant attitude.
Do you have a martyr complex?
No, I don't.
Well, do you see that coming out of this that you can be a hero in the civil rights movement?
I do not have that kind of complex. I don't like all of the attention that I'm getting. I don't. I would not, even if I liked the attention, I would not lie to get attention.
Well, the issue of fantasy has arisen. You have a degree in psychology from the University of Oklahoma State University. You studied in your psychology studies when you were in school, and what you may have followed up with, the question of fantasy. Have you ever studied that from a psychology
To some extent, yes.
What are the traits of fantasy that you study and as you remember?
As I remember, it would require some other indication of loss of touch with reality, other than one instance. There is no indication that I'm an individual who is not in touch with reality on a regular basis that would be subject to fantasy.
The reality of where you are today is rather dramatic. Did you take, as Senator Biden asked you, all steps that you knew how to take to prevent being in that witness chair today?
Yes, I did. Everything that I needed to do, I did.
There may be other motivations. I just listed some that you usually look to relative to these. Are you interested in writing a book?
No, I'm not interested in writing a book.
In the statement that was made, which we refer to as an affidavit, do you have a copy of that?
Yes, I do.
Mr. Chairman, just for part of full record, I would move that that statement be made a part of the record.
Without objection, it will be made part of the record.
You describe on the second page, starting at the first paragraph there, about the working relationship and the various conversations which you say were very vivid and very graphic, pertaining to pornographic materials and films and other statements of that nature. Then you end that paragraph with these words: however, I sense that my discomfort with his discussions only urged him on, as though my reaction of feeling ill at ease and vulnerable was what he wanted. In other words, you're basically stating that appeared to be his goal, rather than trying to obtain an intimate or a sexual relation with you. It may be that you also felt that. But though that raises quite an issue, however, I sense that my discomfort with his discussions only urged him on, as though my reaction of feeling ill at ease and vulnerable was what he wanted. What do you mean by that? How do you conclude that?
Well, it was almost as though he wanted me at a disadvantage, to put me at a disadvantage, so that I would have to concede to whatever his wishes were.
Do you think that he got some pleasure out of seeing you ill at ease and vulnerable?
I think so, yes.
Was this feeling more so than a feeling that he might be seeking some type of dating or social relationship with?
I think it was a combination of factors. I think that he wanted to see me vulnerable, and that if I were vulnerable, then he could extract from me whatever he wanted, whether it was sexual or otherwise, that I would be at his under his control.
Now, as a psychology major, what elements of human nature seem to go into that type of a situation?
Well, I can't say exactly. I can say that I felt that he was using his power and authority over me. He was exerting a level of power and attempting to make sure that that power was exerted. I think it was the fact that I had said no to him that caused him to want to do this.
You cite the instance of the Coke can and his statement of pubic hair on it. Do you feel that he was attempting to have some specific message by relating that? How did you interpret that?
I did not have a clue as to how to interpret that. I did not know. It was just a very strange comment for me. I could not interpret it. I thought it was inappropriate, but I did not know what he meant.
Now, was there an occasion when you were at EEOC that you wanted a different job or a promotion or a higher job?
I never thought of promotion with Clarence Thomas while at the EEOC. I never thought of promotion with anyone while at the EEOC.
Well, did this Allison Duncan, in effect, take over some position or become a supervisor of you as opposed to what had previously been? And was it a reorganization, or what was the facts pertaining to that?
When Allison Duncan took over her position, let me say this, prior to when Allison Duncan moved into the office of the chair as an assistant, the assistant had basically been reporting directly to Thomas. And what I understood happened was that the work got too much for him to handle, to dole out to the assistants himself. So he reorganized the structure and appointed Allison as the chief of staff for the special assistants in that office.
Now, I was expecting to ask you about the USA Today report of October the 9th, 91, which it recites that Anita Hill was told by Senate staffers her signed affidavit alleging sexual harassment by Clarence Thomas would be the instrument which quietly and behind the scenes would force him to withdraw his name. Keith Henderson, a 10-year friend of Hill's and a former Senate Judiciary Committee staffer, says Hill was advised by Senate staffers that her charge would be kept secret and her name kept from the public scrutiny. Have you had a conversation with Keith Henderson during the period of time from where you were originally contacted by some staffers from the Senate and the time that this newspaper account occurred?
Yes, I did.
You did. All right. And what was your conversation to Mr. Henderson? What did you tell him?
Well, my conversation was that I was really concerned about the situation involving this issue, that I had made the comments to the staff, that I had followed up on those comments with an affidavit, and that I'd gone through the investigation, all with the understanding that this was not going to be a public matter, and that I was concerned about whether or not the information would be made available to all the committee.
Well, during any conversation with Keith Henderson, did you tell him that certain staffers had told you that you went ahead and signed the affidavit that might be a way to get him to withdraw?
No, I did not tell him that.
Well, did you tell him that was mentioned, or that it would have been mentioned relative to this?
No, I didn't tell him that.
Do you know whether or not Keith Henderson talked to certain Judiciary Committee staffers?
I did not. I don't know whether he did talk to Judicial Committee staffers.
You know whether in any conversation that he might have talked to judicial staffers, they might have said that is a possibility?
Do I know of any conversations?
Well, do you know whether or not that there was a conversation between Keith Henderson and some staffer in which they were discussing the affidavit and saying that there were certain possibilities, which included the possibility that Clarence Thomas might withdraw his name?
That might have happened, but I haven't talked with Keith Henderson about that.
All right. You were at the EEOC. Were you there on November the 23rd, 1983? Would you have been there then?
No, I was not there then. I left for Oral Roberts University.
When did you leave?
I left in July of 1983.
Have you read a story in the Washington Post today, Friday, October the 11th, in which there is mentioned a case involving allegations that Earl Harper Jr., a regional attorney in the EEOC Baltimore office, had made unwelcome sexual advances to several women in his staff. When you were there at the EEOC, do you remember anything about a case being alleged involving Earl Harper, who was a trial attorney at the Baltimore office of EEOC?
I don't recall any case.
Since you graduated your scholastic work, you written law review articles?
Yes, I have.
How many law review articles have you written?
Oh, I've written 6, 7, including short law review articles. Let me back up. I've written 5 law review articles, some shorter pieces for journals.
Now, while you were at the Office of Civil Rights of the Department of Education, according to the way I read the statement, most of these instances pertaining to descriptions of pornographic films and materials was mentioned to you, rather than most of the conversations concerning that at the Department of Education as opposed to the EEOC office?
I think the more explicit statements probably did occur at education more than later at EEOC.
Now, but they did occur some at EEOC.
Yes.
Now, how old were you at this particular time that you were at the Department
I was 25. I just turned 25 when I started the job.
Did you have any family here in Washington?
No, I did not.
Did you have other than certain friends that you could turn to in times of difficulty?
I just had some friends. I did have some friends, but no family.
Chairman, I believe that's all.
Thank you very much. What we'll do is we'll recess for 10 minutes, 15 minutes. 15 minutes. And let's have order in here, please. And what we'll do at that time is we'll come back. Senator Specter will question. Then we'll move to senators who have 5 minutes of questions, and hopefully that will be it. And then we'll have, we'll hopefully in due course call back Judge Thomas. Recess for 15 minutes.
And so Chairman Biden, Joseph Biden of Delaware, Chairman of the Senate Judiciary Committee, has called a 15-minute recess to allow Anita Hill a short break. She's been on the witness stand since about 2:15 this afternoon. And in particular, Senator Arlen Specter, Republican of Pennsylvania, wants to ask her about an affidavit apparently filed by Mr. Doggett. We don't know what's in the affidavit. It obviously is something somewhat adverse to Professor Hill's story. And therefore, she is going to read this affidavit during the break. And we will resume with the hearings when they return. And in the meantime, I'm Nina Totenberg from National Public Radio, and I'm joined by Kwame Holman. And you may wonder where Paul Duke is. He has a show to do tonight, and so he's gone off for the rest of the afternoon, and Kwame is sitting. And Kwame, have you read this affidavit?
Nina, this was just passed out to the members of the press about 10 minutes ago. It is, as you said, the affidavit of a John Doggett, who was with Professor Hill at Yale Law School and other places as well. The substance of the affidavit seems to be Mr. Doggett's assertion that Professor Hill at a party confronted Mr. Doggett and said to him, "I am very disappointed in you. You shouldn't lead women on, then let them down." Mr. Doggett asserts in the rest of the document that he felt that Professor Hill had a mistaken idea that he, Mr. Doggett, was interested romantically in her, and he goes further to suggest at the end of the document that Ms. Hill has a problem being rejected, and he suggests that might be reason for rejecting her allegations against Judge Thomas.
Now, when she was asked initially by Senator Specter whether she knew Mr. Doggett, she said yes, she did. And when asked even more specifically what her relationship with him was, she said, "I don't know what my relationship was." At that point, there would seem to be such general sort of confusion, even in the witness's own mind, about what was going on, that Senator Specter said he would allow her to read this affidavit before he questioned her about it. I would say at the moment that we have two extremely unshakable witnesses here. We saw first this morning Judge Thomas testify very emotionally, very passionately, denying these allegations, saying, "Give me my good name back. I never did anything that she said I did, and this process has eviscerated me, in essence." And then for the rest of the day, for the large part of the day, we have seen Anita Hill under some very tough scrutiny by this committee, never really break once. Almost every wrinkle that had been thought to be a difficult problem with her assertion, she has an explanation for. And she said at one point, "I realize that there are some inconsistencies here." For example, her continued contact with him. But she said she didn't want to burn her bridges. She thought it was professionally important to stay in touch with him. And therefore, she said, "You'll have to make the judgment yourself, Senators." been on the witness stand now for many hours, and as far as I can see, you tell me what you think. As far as I can see, I can't see that she's been shaken.
Indeed, Nina, and being with my colleagues at the NewsHour, as we all were riveted by this testimony earlier today, both from Judge Thomas and from Professor Hill. Indeed, during some of the questioning, as she was pinned down to the specifics of the events and conversations, she became more specific. She remembered more, seemed to be adding more to the testimony, thereby, in the eyes of many, improving the odds that she should be believed.
Now, I'm sure that there will be people, and I'm sure there are senators on this committee, who will say, well, you remember more details now. You've supplied us with 2 more witnesses, people that you say you told about this contemporaneously. That's powerful strength. You make a very serious allegation, and suddenly you come to new ideas. She says, I repressed a good deal of this. This is the kind of judgment call that juries make, and this committee, acting as a jury, is going to have to make it. And in the room are supporters of both the nominee, Clarence Thomas, and the witness, Anita Hill. And a lot of Clarence Thomas's supporters are women. Women he's worked with, women who care for him, women he has cared for as professionals and as friends. And we are joined now by one of those, Patricia Johnson, who serves as the Director of Labor Relations at the EEOC, and who has known Clarence Thomas for how many years? Since November of 1987. And you were one of the women at yesterday's press conference. There was a sort of what I would call a pre-hearing hearing. A lot of the women who know Clarence Thomas got together in the press gallery and to talk to reporters about the Clarence Thomas they knew. So as we sit here listening to Anita Hill's description of the Clarence Thomas she knew, tell us about the Clarence Thomas that you know as a female professional and as somebody who you say that you also have been sexually harassed on the job. I understand you did not discuss that with Judge Thomas, but tell us about the Clarence Thomas that you know.
Clarence Thomas always treated me with the utmost professional respect and dignity. He was the chairman of the Equal Employment Opportunity Commission. He was an individual who frowned upon profanity being used, so I would suggest that he was almost prudent in his outlook. I thought his statement today was a very moving, a very compelling statement. I have listened to the testimony of Anita Hill, and she has certainly embellished her allegations. I said yesterday that the allegations were inconsistent with the man I knew and the man I have worked with. As I have listened to the details of the statements he is alleged that he made, I just find it absolutely incredulous. This could not have been done by the man I knew. I guess this dogged statement perhaps would cast some insight into what has motivated this woman, because that has been the $100,000 question. Why would she come forward and say these things about him? And perhaps the answer lies somewhere in that affidavit. But I must say to you that there's no way the man I knew and the man with whom I worked would have done the things that she has suggested today.
You have never seen any behavior towards any employee at the EEOC such as she has suggested?
Absolutely not. Absolutely not. As the Director of Labor Relations, it was my responsibility to draft decisions concerning grievances that were filed by employees for his signature. Not very often, but on occasion, we had to deal with an allegation of sexual harassment, and I would work with him and his office in drafting those decisions. I must tell you that he took a dim view of individuals who were even accused of inappropriate conduct.
Thank you. And what about the other women you work with? What's the feeling at the EEOC right now?
The women are angry that this individual has made these allegations, speculation about why she would make these allegations. There's a lot of sadness.
incredible, just absolutely incredible. It is inconsistent with the individual we know.
Okay. Thank you very much, Patricia Johnson. Ms. Johnson is, as I said, Director of Labor Relations at the EEOC and has known Clarence Thomas since 1987. And she is typical of a lot of the women that we heard yesterday, some of whom cried at this press conference, detailing their impeccable relationships with Clarence Thomas and with what great dignity he treated the women professionals in his office. We have some indication now that we are getting close to the end of Anita Hill's testimony. Senator Specter will question next. He will ask about this statement from Mr. Doggett, and we were just handed it a few minutes ago, so we're feeling around a little bit too, and I'm just going to read you a couple of excerpts from it. The last time I saw Anita Hill was at a going-away party that her friends held for her at the Sheraton Carlton Hotel on K Street just before she left for Oral Roberts Law School. During this party, she said she wanted to talk to me in private. When we moved to a corner of the room, she said, "I am very disappointed in you. You really shouldn't lean on women and let them down." When she made that statement, I had absolutely no idea what she was talking about. When I asked her what she meant, she stated that she had assumed that I was interested in her. She said that it was wrong for me not to have dinner with her or to try to get to know her better. She said that my actions hurt her feelings and that I shouldn't lead women on like that. Quite frankly, I was stunned by her statement and told her that I felt her comments were totally uncalled for and completely unfounded. I reiterated that I had never expressed a romantic interest in her and had done nothing to give her any indication that I might be romantically interested in her in the future. I also stated that the fact that I lived 3 or 4 blocks away from her never came over to her house or invited her to my condominium should have been a clear sign that I had no personal or romantic interest in her. I came away from her going-away party feeling that she was somewhat unstable and that in my case she had fantasized about my being interested in her romantically. And that's sort of the sum and substance of this. It was my opinion at the time, and it is my opinion now, that Ms. Hill's fantasies about sexual interest in her were an indication of the fact that she was having a problem with, quote, being rejected by men she was attracted to. Her statements and actions in my presence during the time when she alleges that Clarence Thomas harassed her were totally inconsistent with her current descriptions and are, in my opinion, yet another example of her ability to fabricate the idea that someone was interested in her when, in fact, no such interest existed. So that's the general outline of Mr. Doggett's affidavit. It is the only such suggestion other than Charles Coffey's statement. Mr. Coffey was the founding dean of Oral Roberts Law School, and he said that he found her charges against Judge Thomas preposterous, and he believed them to be the result of fantasy. In his case, it was speculation. In this case, I suppose you could say it is speculation, but it is at least based on some alleged behavior or at minimum misunderstanding, perhaps. It'll be very interesting to hear what Anita Hill has to say. But this goes to the question of motivation, Kwame, and why she might conceivably have thought that Clarence Thomas was interested in her in this way. I must say it doesn't explain the specificity of some of her testimony, do you think?
It does not seem to. It seems that a couple of the Democratic members, as we heard just before the break, Chairman Biden and Senator Heflin, both were interested in that question of motivation that you just mentioned and that Ms. Johnson mentioned in terms of why she would want to do this. Senator Heflin noted, saying to Professor Hill, you could become a hero, suggesting that if the nomination is derailed, those who were opponents would see you as a hero. She sort of shook her head and said, I don't like the attention, and that even if I liked the attention, I wouldn't lie to get it. So there seems to be some sensitivity to those questions being raised about her motivation.
Well, and in addition, she was asked by Senator Heflin about the fantasy question, and she said, look for some other indication in my life that I'm unstable and that I have fantasies. Now, I suppose the only thing that we know about is this Doggett affidavit, And to be fair about it, one must say that in relationships between young men and young women, there are often misunderstandings, and I'm not sure this is what you might call a silver bullet. But it'll be very interesting to see what her explanation is. We heard from Clarence Thomas this morning, once again, in case you're joining us right now, his absolute, emphatic, categorical denial that he had ever engaged in any sort of improper behavior, conduct, speech, commentary with Anita Hill. He said he was deeply hurt by her allegations, that he had helped her at every turn in the road, and that these charges were totally untrue. And he said that he thought he could withstand anything when he began this process, but the process, in his words, had turned out to be Kafkaesque, and that enough, as he put it, enough is enough. He said he wouldn't answer questions about his private life, that he was not going to allow the committee into his bedroom. I'm not entirely clear what that means. I assume it means that he will not answer questions about his personal sexual behavior outside of the office, which of course is not at issue here. And Chairman Biden made very clear that he would not ask any of those kinds of questions. But Mr. Thomas, when he comes back, is certainly going to be asked item by item, did you ever say X? Did you ever say Y? Did you ever do this? Did you ever do that? And he will almost assuredly say no, because he's already said no. And as I said, Kwame, earlier, what we're down to here is two individuals of the highest achievement and reputation, one nominated to the Supreme Court of the United States, the other a tenured law professor at a relatively young age at the University of Oklahoma, admired greatly by scholars and judges alike who know her, and both of them are here telling diametrically opposite stories, and one of them is not telling the truth.
Very apparently, Nita. And then, in that regard, I was so interested in that question, the diametrical opposition of two apparently credible witnesses, that I wondered how an EEO officer who deals with these kinds of things would respond to what probably is a fairly common situation, as we've heard in all the coverage of sexual harassment. I called one here locally and spoke to him, and he said, interestingly, that one of the things they try to do is they look for two things. One of them is whether the victim has spoken to someone else contemporaneously about the same time that these allegations were occurring, and two, whether there was anyone else who alleges that individual harassed her. I found it interesting that after lunch, Senator Leahy got into the record Ms. Professor Hill's assertions that she had indeed told other people, friends and the new friends she remembered, who she told about Judge Thomas's alleged actions, the beginning of the setting up of almost a legal case, although Chairman Biden has told us this is not a legal proceeding.
Well, one of the things that's sort of interesting about this case, there's been a lot of talk about the way the Judiciary Committee handled it, and you can hear from Chairman Biden's questions that they are very sensitive to this question. And certainly Anita Hill has testified that she didn't want to go public. I think it's fairly clear from the record that senators on this committee did not tell her very specifically early on that these were the choices. You either go public or this is no deal. That you can't make this kind of a charge and not have it aired in some way. It's not fair to the nominee. You can't just have anonymous charges like that. So that early on, she seemed to be under the impression that if she made a statement, and then if she made an affidavit, and the committee could see the affidavit, and then later maybe the nominee could see the affidavit, that there wouldn't be any public repercussions. But if you think it's true, it would have been powerful odds. Even if you assumed that she was telling the truth, if suddenly a nominee pulled out for no reason, no apparent reason, we in the press certainly would have been bloodhounds trying to find out what the reason was. So it doesn't, in terms of reality, it doesn't make an enormous amount of sense. But nobody in a high position really explained that to her early on. But what the product investigation that bollocksed up. And the way that investigations are normally done, I too have asked investigators, is quite different than this. Now, obviously, this is not a typical EEO investigation, but what is typically done is I make a charge that you have harassed me. Investigators then go out and interview every single person that's ever worked for you and ask whether they've had experiences like that. I am asked whether I've told anybody. All those witnesses are interviewed. And then the person who is charged is interviewed and asked, have you ever done X? Have you ever done Y? And the interview is taken from the general to the specific. Well, obviously, none of that can happen here because the charges were made public first, and it's all very confused, and there's no method to this madness in a way anymore. And the committee is doing its best to try to sort it out now. But the very process by which this became public, of which I was part, has in many ways made it more difficult to determine what the truth is.
Indeed, you mentioned that reality, and I think it's the reality we see everyone reacting to, from Professor Hill to Judge Thomas. We're right at the point where books are being written and much is being said about the power of the press and or the press's new focus on scandal and related issues to the exclusion of substantive ones. This issue certainly has those elements of prurience and that kind of scandal. I don't think that the nominee nor certainly Ms. Hill, the way she seems to have reacted in the last 36 hours, is really ready for to some extent those of us in the press aren't ready for the huge attention that this issue has gotten, the many ways that it reverberates throughout society, workplaces throughout the country.
Well, one thing that's certainly true, and it's obvious to anybody, is that this issue coming out this way has seemed to have ripped the scab off of some sort of sore in the workplace, a sore that women had never talked about. My phone has just been nonstop, and it's not all nice. Some of it is very unnice phone calls, and some of it's very nice phone calls. But obviously, this is a subject that men and women really have not discussed and has been there festering as women became more and more prominent in the workplace. And I suspect it'll be the cover story of most major news magazines in the country. Not just this nomination, but the issue of sexual harassment, and that it's something that will now get some attention. I do think it's important that we say here that it should not be trivialized. You know, I do hear people talking about, a guy won't be able to say anything to a woman on the workplace. There are inappropriate things to say, and there are inappropriate things to say. And Clarence Thomas would be the first to say that. He has denied saying the things that Anita Hill charges. He has said, would say, that this kind of conduct is totally inappropriate, that it is classic sexual harassment, even though there was no touching involved, no direct threat of a job. But he denies that he ever did the things that she says he did. And he denies it repeatedly, emotionally, passionately, and categorically.
Indeed, Nina. Some of the quotes you recounted, I would just add from paraphrasing from Judge Thomas's opening statement. He said, I can't imagine anything that could be considered sexual harassment. That's a fairly unambiguous statement.
That's absolutely right. Well, there are some senators who are ebbing back into the hearing room, so we expect this hearing on the nomination of Clarence Thomas to the Supreme Court to continue momentarily. And Senator Specter will be the questioner when we resume. He is the designated questioner of Anita Hill and of all of her witnesses for the Republicans. He is a skilled former prosecutor. I think it's probably fair to say that he is the most skilled questioner, perhaps in the whole United States Senate, having been a very experienced prosecutor. There are other prosecutors. on this committee. Senator Leahy, for example, is a former prosecutor. But Specter, this is really his strongest point in his arsenal of talents. Everybody has things that they do well and some things that